I think we are live. We might be a few minutes late, guys, but hello, everybody. Can everybody see me here? Let me go find the video on YouTube. I'm trying to rush around here, get everything up and go. There we go. I got it. There we go. All right, guys. So today, thank you, Viking Mop. It was I enjoyed that stream. I hope everybody else did too. So today, we're going to go back into the law. And remember, from yesterday's events, let me make sure Mr. Alphonse can get in. Yes, sir. I said it for the time he wanted now, mind you. So today, what we'll do is we'll go through the insanity that you will face inside these courts, right? And Alphonse has his issues. Brother Gary has his issues. Of course, anything that Gary and I do together, we usually work on at the same time. The next level I'm writing right now, which would be my daughter's lawsuit against the hospital for violating her rights, right? But until you get into the fight, you don't realize just how nasty it can get. And so with that, and before James and Alphonse make it onto the show, we'll start going over some of these things here, and we'll give. You're not in here. Hold on. Did I give them the wrong thing? Hold on, guys. I may have given them the wrong. I may have given them the wrong thing. Hold on. What? No. Did I not? Let's see. Uh-oh. Let's see. Hold on. I don't know if I can invite. Yeah, hold on. Let me do this. Copy. Let's go give this to Alphonse. Hold on. Paste. There we go. Forward. James. There. Okay. I think I may have given him the wrong link. Let me see that. Yeah, I did. I gave him the wrong link. Sorry about that, guys. That's my bad. You know, I'm not a stream operator, guys. That's just a fact. That's just a fact of the situation. Hey, Alphonse.
What's happening?
How about that? I sent you the wrong link.
I seen it said the chat ended. I'm like, wow, what happened?
I'm sorry about that, bro. Yeah, I sent you the link to my live stream yesterday. So I was just catching people up. I was just catching people up. What I want to do first is give a picture from the federal level, and we should get James in here soon too, because James is running into the same thing. So, but what I want to do is kind of explain to people leading up until now why I've been kind of quiet. Okay, and I'm no longer going to be quiet anyway, because it's gone so far outside the box and outside the pleadings. I don't think there's any way that the judge can rule anything but sanctions on this attorney. So, without further ado, I want to catch people up. And what I'll do is I'll share the screen. Hey, Brother James.
What's going on?
Oh, nothing much. So let's start. Let me turn that off, and let's start. So I think James is going to be able to relate, and I know Alphonse is going to be able to relate. So I'll catch everybody up here as we move forward, and I'll start sharing all this stuff. So this is an order from the judge. Let me turn that down a little bit. And this is an order from the judge on October 14th. Now, leading up to this point, the attorney had one committed libel. And let me catch everybody up here. he actually claimed that another attorney was writing my stuff, named that attorney, and then asked for sanctions on that attorney. Well, after he recognized that, I put a motion in limine to exclude the affidavit, which is hearsay, which is a violation of Rule 803 and inadmissible by Rule 901. So once he realized the mistake, he quickly shifted gears and started another tactic of obfuscation, stonewalling, and harassing the plaintiffs. And what was that? Well, I'll show you this, guys. This is pretty pathetic right here. But welcome, each and every one of you, to exhibit number 2. And I'll remove our faces and show y'all this. So I'm going to blow this up a little bit. Do y'all see y'all's names? There's 29 pages of YouTube comments now in the record.
What purpose does this serve exactly?
Exactly. But let's go back and we'll read this one little section right here. All right, let's read this one little section. This is an affidavit, the new affidavit of Kyle James Boobinghausen. Now,
that's a name.
His first-hand evidence and witness testimony is not to anything in the case. It's about Brandon Sibley's ideological views and his YouTube videos.
Let's go. He hates old people and animals.
Right. So, and we'll just go here. And he misquotes me too, because I lambasted and ridiculed the notion that private attorneys are officers of the court, because that would mean they should be acting in cahoots with the court and opposing counsel moving toward a common goal, which plaintiff Sibley asserts would be a communistic system. It's not asserting it would be a communistic system if there was not due process of law. But anyway, this is the route that the attorney has gone on. And why does it even matter? All right, guys, ladies and gentlemen, if you don't know this, when you form a pleading, right, everything inside that pleading should have everything that this case is about. Everything outside the pleadings trying to bring it into the court's view is usually character assassination or something like that. But at the flurry of motion stage, my character is not up for a questioning. One, Rule 610, Federal Rules of Evidence, states that my religious views are not up for discussion. So my ideological views aren't part of the record. At this point in time, this attorney, who has spent so much time outside the pleadings, making claims of ghostwriting, watching my YouTube videos, and filing 2 affidavits on the record, both of which are inadmissible evidence because they have nothing to do with the pleadings, is now faced with the very real possibility of sanctions. So we'll read the order from the judge. We'll read the judge's order together. Okay, let's do this. On June 22nd, defendants filed motion to dismiss 4 and 6, asserting that the court lacks subject matter jurisdiction over plaintiffs' 1983 claims and that plaintiffs failed to exhaust their remaining claims in tribal court. On August 16, 2022, the court ordered further briefing on those motions. Order 16. After defendants moved to dismiss, plaintiffs filed a slew of motions: a motion to strike, 2 motions in limine, 2 motions to show cause, a motion for partial summary judgment. So let me back up right there, guys, just so you know why I have been kind of, you see how many motions we are in this case? We're up to 42 motions in this case.
Yeah, you want to talk about flurry of motions? You guys are swimming in those motions.
42 motions at this point. Okay,
that's freaking ridiculous.
It is crazy. So defendants filed a motion to stay, asking the court to stay all proceedings pending a ruling on the motions dismissed, except for Rule 11 matters. While there are no Rule 11 motions pending, oh yes, there was. Yes, there was. The court knew it. Defendants have also moved for a status conference seeking direction from the court on how things should proceed from here in light of the several pending motions, some of which would be made moot by rulings on other motions. Plaintiffs oppose the motion to stay, arguing that the only question moving forward that need be answered is whether the tribal chief operated within his official capacity and lawful confines of his office. While the court recognized the plaintiff's strong desire to move this case to the merits, the district courts of the United States are courts of limited jurisdiction, defined within constitutional bounds by federal statute. Now, let me catch y'all up why that's an important statement by the judge. Because the truth is that the Choctaw Indians and the tribal chief operated outside their statutory bounds, which is Title 18, Title 25, Section 1302, which means no tribal chief can enact any law that restricts religious or unlawfully searches and seizures. It's all in there. It's the same thing that's in your constitutional rights. So the first question in any court, especially federal courts, when you're looking at a statutory construction, is it constitutional or not? That's the only question that remains, and whether it was a lawful exercise of power. And that's why I put it in my paperwork. So the motion to stay, and look, I'm just going to discuss Carl Bryant here. So Sunday, I reached out to him and told him, by the way, your time's come and gone for your sanctions. And Carl Bryant, who read the same response that I just read, emails me back and says, oh, you can't file any motions for sanctions. Is that what this says? No, let's go back to it. Except for what?
Rule 11 matters.
So it's filed. The sanctions are filed. And we'll discuss this a little bit too, guys, because there's a point here that I want to make to y'all. These people that we're up against have no earthly idea what the law is. When I say law, I mean life, liberty, and property, and the simplistic nature of that. I know from the doctrine of, the reasonable man, that as long as I'm not hurting the life, liberty, and property of someone else, that I'm inside the law, the lawful bounds of it, right? And this 44-year Harvard graduate and law degree major, super lawyer, whatever, has no earthly idea what the law is. And they're so used to going in these courts. Every citing that he has given me has been a corporation against a corporation. There has not been any Article 3 standing courts where a constitutional right was violated. And they're so used to using this sovereign immunity that he doesn't recognize that scarves, bandanas, and other suitable fabrics is language so vague and ambiguous with not enough specificity that it can nowhere, in no way, shape, or form give somebody the lawful authority to arbitrarily discriminate, right? So he's got a problem, and so does the court, because now the court has to rule against precedent. And why does it have to do that? For so long, each one of these kangaroo courts were protected. One, the local municipalities, we see it whittling away with qualified immunity, right? And then two, with this sovereign immunity of the states, where they can just pass unlawful edicts themselves and just go on about their business. Well, those days are swiftly coming to an end, because the truth is sovereignty. I'm going to read this 5 or 6 paragraphs of my sanctions, and there's a reason I wrote it this way. So I went and read some of James spoke about this before. I went and read Daniel Jordan's Findings of Fact, Conclusions of Law, and his How to Persuade a Judge. Right? I went and did that. So when I wrote these sanctions, I'm appealing I'm going outside the framework of just law. Now I'll read this to y'all. And what all the sanctions does now is I did a motion to show cause. Okay, why he shouldn't be held in contempt. He doubled down from there, made allegations that somebody was ghostwriting, and then he's done 9 motions on my YouTube channel, guys. 9 motions on what I said.
Listen, here's what he's doing to him, okay? Listen, when you file a complaint, if you ever heard the 4 corners doctrine, what that means is they can't move outside of the 4 corners of what's in your complaint. So the problem he's got is he really can't address the complaint that he wrote. So he stepped out of the 4 corners of the complaint, bringing up YouTube videos and his theory. Why? He's going to judge you. He's got he knows your whole philosophy on law. From, did you write a book or something that he studied? That he knows your philosophy of law. So This is a common thing what attorneys do is they will move outside of the four corners of what you write. And you need to
All
go,
the
no,
time.
no. We need to deal with what's in here. That's it. We don't care about what's out there. You need to beat my complaint.
Yeah,
You know, and here's something too that I found out, you guys. I don't know if you knew this, but you know that Rule 12H2 prohibits successive 12B6 motions to dismiss.
say that again.
So Rule 12H2, Federal Rules of Civil Procedure, prohibit more than one 12B6 motion prior to an answer to the complaint.
12H2.
So we don't get 2, 3, or 4 bites at the apple. He's got to
No,
take
they
one
do not.
shot at it, and that's it.
So if you look at the rule, which I have it,
I'm pulling it
Brandon,
up right
are you
now.
pulling it up right now?
Yeah, I'm pulling it up right now.
Okay. All right, perfect. So if you look at the rule, there's only 3 situations where if they allege, 12B6, which is failure to state a claim. So if they allege that, let's say, for example, like in my situation, you file your complaint, they file a 12B6 motion, you file an amended complaint. Well, now they're not supposed to file another 12B6 motion, but they do. They do every time.
Yeah,
So
they
out.
do.
You have to point out that there's a few different things that are wrong with that theory. One of them is the fact that any defenses that are not raised in the first motion to dismiss are waived in the second.
Well,
So
that would go back to the same thing because the motion to dismiss is a dispositive motion, which is in the place of an answer, right?
Exactly.
And that's why that would be so.
Yeah. So it's not here. Go back to Rule 12.
Okay.
You're in Rule 12.2. I'm not sure where that. Oh, you're in the criminal procedure. No, you want to be in.
Okay. Hold on. Federal Rules FRCP rule. Oh,
Just go to Rule 12. There you go.
there you go.
Perfect. So scroll down there. So if you go to Rule 12H2,
I see it. Mm-hmm.
failure to state a claim upon which relief can be granted, when to raise others is what it says, may be raised A, in any pleading allowed or ordered under Rule 7A, B, by a motion under Rule 12C, or C, at trial. Make sense?
Yep.
So when you read further on, motion for judgment on the pleadings, well, okay, so they're asking for a summary judgment.
That's right.
So there's got to be teeth. There's got to be something supporting that.
Well, and that's why after you see the motion so let's go back here. Okay. Come on. And I just want people to follow the logic here of myself. Let's do this. Let's go back and read right here. You can see that the plaintiff filed, and all we have here so far from this guy is 1,000 different motions to dismiss. Okay, each one another level of garbage. A motion to strike, 2 motions to show cause, and then a motion for partial summary judgment. And I'll tell you why we went for the motion for partial summary judgment is because at no time had the attorney brought up any genuine dispute of material fact after 30-something pleadings. I mean that's it. He's had 30-something different motions about dismissal, and the only thing he's brought up is 105 times the tribal court jurisdiction.
It never ceases to amaze me. I mean, not one of the cases that I'm involved with, not one, is there anything that's even remotely close to evidence on the record from anybody that I'm suing. Nothing.
Nope.
Nothing even close. And again, and this is why I say, you guys, you need to realize too that more often than not, even if you do not consent to a magistrate judge, these motions are submitted to magistrate judges for their report and recommendations. So here's something else I'm going to throw at you. Within those same rules, Brandon, I don't know if we still have those up.
Yep.
Within those same rules, go to Rule 72. So scroll down there to Rule 72, magistrate judge pretrial order. So under Rule B1, findings and recommendations, it says a magistrate judge must promptly conduct the proceedings without the party's consent to hear a pretrial matter dispositive of a claim or defense. Obviously, this isn't a prisoner petition challenge, and it says a record must be made of all evidentiary proceedings and may be made of other proceedings. So what does that say?
The judge must enter a recommended disposition, including, if appropriate, proposed findings of fact.
Exactly. In addition, it says that they must make a record of all evidentiary proceedings.
And
So-
you know what's funny, James? Before you even take off, and I don't know if it's the particularity of the Indians, I haven't had a magistrate say anything in this matter.
So yours has all been the district court judge.
It's been all by Daniel Jordan, the chief judge.
Well, maybe it might be why, because of the nature of the case.
Come on, Zeke.
That's possible where you're at.
Yeah,
Here where I'm at, every single case and motion that we've filed has been referred to magistrate judges. I got you guys know I got a report and recommendations from this magistrate judge where she was clearly biased for the defendants, clearly, and I excoriated her. I freaking ripped her to shreds, as we should. And if I don't get a favorable ruling from the district court judge, I got a judicial complaint just waiting. I can't wait to hold that hearing with the Circuit Court of Appeals, because that's how they do those.
Well, and really the purpose of this, folks, is look, you're coming into battle here, and especially we'll go further into Alphonse's tax stuff, but there's no separation from none of the ideas. We're looking for adults who understand the rule of law, okay, and what that is. And make no mistake that your adversary here, this for instance, I'll speak from my experience, right? From Gary's position of the failure of the municipal lawyer to waive the statute of limitations timely when he answered the complaint. And man, that's not a small mistake. That's a big time mistake that he did. Mm-hmm. But he failed to waive. Now we have a super lawyer, top 50 law firm in the United States, committing libel against another attorney on hearsay evidence from two non-party members having a phone conversation, and actually submitted that affidavit on the record as evidence. That leads me to believe that the operation of the courts have been in such disarray for so long that they think this is commonplace, right? That the rules are not being followed, because you've got a 44-year-old Harvard graduate, summa cum laude, super lawyer, and he doesn't know the rules of evidence. This is pretty pathetic. And I think we're seeing this all the way across the board. Even Gary's lawyer is whining to the court because he just didn't have enough time. He's got too much case. But that's not our problem.
No, that is not. Hey, can I show you guys this? Can I present my screen?
Yeah. Can I give you the screen? How do I do that?
I think you did. Yep, I'm good.
Okay. You
should be seeing my screen now. So nope. Take a look at this.
Not seeing it.
Is it coming up yet or no?
Oh, I got it. I know.
All right.
There we go.
Schwartz v. Apple Inc. All right. So this is the service I subscribe to, case text. It tells me if it's got positive history, which it does. This is from the 9th Circuit from 2017. Okay. Here's what I want you guys to see. I'm going to scroll down here to the highlighted section. Okay. Late filed motions to dismiss under Rule 12b-6. Rule 12g-2 provides, except as provided in Rule 12h-2 or 3, a party that makes a motion under this rule must not make another motion under this rule raising a defense or objection that was available to the party but omitted from its earlier motion. The consequence of admitting a defense from an earlier motion under Rule 12 depends on type of defense omitted. A defendant who admits a defense under Rules 12b 2 through 5, lack of personal jurisdiction, improper venue, blah, 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 entirely waives that defense. A defendant who admits a defense under Rule 12b 6, upon which relief can be granted, does not waive that defense. Rule 12g2 provides that a defendant who fails to assert a failure to state a claim defense in a pre-answer Rule 12 motion cannot assert that defense in a later pre-answer motion under Rule 12b6, but the defense may be asserted in other ways. You guys catch that?
Yeah, and I like this next paragraph too. I'm reading on, and how we have a different appellate court reading it a different way and applying it a different way. Isn't that wouldn't that make the rule itself void for vagueness?
It would.
So you have two different interpretations by two different appellate courts.
Yeah. Well, so look at it here. So this next section that's highlighted, if a failure to state a claim defense under Rule 12b6 was not asserted in the first motion to dismiss, Rule 12h2 tells us that it can be raised, but only in a pleading under Rule 7 in a post-answer motion under Rule 12c or at trial.
So that's an answer.
Yes.
And it's really an answer with an affirmative defense.
Yes. So what this states is you file your complaint, they file a 12b6 motion. You file an amended complaint, they cannot file another 12b6 motion. They must answer your complaint. They can file a 12b6 motion, but only in response to a pleading. In this case, would be an answer. So they would have to file an answer and then file another 12b6 motion. I mean, does that make sense? What the courts are saying here?
No.
I mean,
well, it makes sense to me. What I don't understand is the simplicity of this, right?
Mm-hmm.
So from my perspective now, I have here. Let's pull it up and let me not lie. Let me not lie because I just want everybody to see. All right, yeah. Let's do this so you all see this. This is the docket list.
Oh boy.
And there's been 4 more filed that's not on here. Okay, this is my docket list of one case. Look, folks. This is simple. Let's just tell it what it is. This is harassment.
Yeah,
it's intentional. I've gotten books this tall that I've had to deal with in order to combat the frivolous filing nature. Now, of course, this guy's probably made $150,000 so far.
He doesn't care. But I based on that order that I saw from that judge, I would not be surprised if he's going to hand down those sanctions.
Oh, I don't think so. I think he is too. And look, so me and Gary sat a week. We sent the sanctions last week. We didn't know if he was going to file them. And again, before I get too far out the way, let me go ahead and read the sanctions to you, because you guys. And there's a reason why I want to read it to you. I just want to read the opening statement. So before I forget, because I'll get sidetracked, especially when we start getting into the nexus. So what you'll see here is a move by myself, Brandon, moving towards what's called persuasive argumentation. Okay. And yes, we have to take into account the continued downfall of all COVID-19 restrictions, right? It's just falling apart at the hilt. But anyway, let's read these 5 paragraphs and see if anybody here can grasp what I'm laying down. Because my counterpart, my opposing counsel, doesn't understand it. Life, liberty, and property are inalienable, fundamental, and inherent rights of existence. Rights which are the very basis of why institutions of men are created. All the laws created by free men include the fact that life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused men to make laws to protect the fundamental principles of existence. The principle of a thing is its beginning, and the sacred beginning of the United States of America's inception of its Constitution is the protection of life, liberty, and property, which are the natural rights of a sovereign people. When through wantonness, fear, greed, apathy, ignorance, or willful disregard to this principle, the governments of men disregard this basic fundamental truth, The reason for the law is lost. And in its place sits a system that not only protects the loss of these natural, inherent, and sacred rights, but vilifies those who would fight to protect them. From a political point of view, there is but a single principle: the sovereignty of man over himself. This sovereignty of oneself over oneself is called liberty. Liberty is restricted to the fundamental principle incorporated into our system of jurisprudence as the reasonable man doctrine. The reasonable man knows his duty to his fellow men and thinks, speaks, and acts in concordance with these principles and minds. When in the common course of events, men devise ways to circumnavigate the principles of our system of American jurisprudence and willfully violate the life, liberty, and property of others by arbitrarily discriminating, absent of any legal or lawful authority, it is the right of the people to redress the courts for grievances. When the aforementioned occurs, attorneys who are trained and supposedly educated to defend these unwarranted attacks on the people instead become protectors of the tyrannical despots who would criminalize man in his natural state of being instead of liberators for the people. While the administrative function of law is relevant and has its proper place in a civil society, the administration of things and objects cannot overcome the supremacy of the United States Constitution, which is the document of limitation on all governments, all states, and all territories. When a man finds his hill upon which to die, he will not be shaken from it. Money or gold will not suffice for the man whose house is built upon a rock. Whether the entire world loses its mind on the current or next mass psychogenic illness brought by cunning politicians perverted by money and greed, it is of no concern to the plaintiffs. The truth will shine on the darkest day in the face of all adversaries to it, and no lie formed by way of legal argumentation, discrepancies in language, or perceived lack of understanding can defend the indefensible position. While defendant's counsel has continued to misjudge and mischaracterize the plaintiffs, let this record reflect the continued intent to delay the proceedings, harass the plaintiffs, and the ease at which counsel commits libel against another attorney to protect his pride and ego. This is astonishing, and Carl Bryant Rogers should be ashamed of himself. And then we go into the details of it. But what I want to show people here is that we have to move back to an understanding of sometimes play. So I'm moving towards the appellate. Already I'm shifting towards writing my appellate brief just in case for some reason Judge Daniel makes a mistake, which I think Carl Bryant has actually trapped the judge into a position where Carl Bryant doesn't ever not get sanctions. I don't see it. But nonetheless, what is most concerning to me, and then I'm going to give the floor to you guys, is the fact that none of these attorneys that I've faced yet, I'm not saying there's none of them out there. There's got to be good ones somewhere. But I haven't faced one yet that understands or grasps the fundamental principles of our system of American jurisprudence.
Yeah.
Now, oh, you're muted, Alphonse. Unmute.
Because the dogs are making a commotion. Listen, these municipal corporations operate under a charter, and it's usually the county charter. And right in the county charter, there's a power section, and it states that the charter is subservient to the federal and state constitution. So now these attorneys operate under this guise that because of the statute, first of all, here's what's going on with your local municipalities. You have two taxing authorities. You have a state taxing authority that generally the county operates under. That's where they're getting their assessments and where they create these assessments. Then you have your local taxing authority, which is the town you live in, the borough you live in. They operate under a separate section of statutes, but the statutes that the local municipalities operate under, they depend on the state statutes that the county's using because they're all operating under that assessment. It all comes off that assessment. All your local taxes, your trash and your sewer and all this other stuff they charge you is all coming off of that county assessment, which is under the state. So most of your problems are going to come with your local municipalities. And here's what's going on. No one I live in the township of Aston. Nobody from the government of the township of Aston is walking into that court and getting up on the stand and testifying that I owe them a tax. It's not going to happen, okay? No one from the legislature, the Pennsylvania legislature, the assembly, and all the assembly is, when you hear the assembly, that means the Congress and the Senate combined. That's what the assembly is. So no one from the assembly, the state assembly, is coming into court stating that Title 53, which is Pennsylvania's local taxing statute, is going to apply to me. So now no one from the assembly is coming in. No one from the Township of Aston's coming in. Who's the only guy making the claim that Title 53 applies to me? It's the attorney.
The lawyer.
The lawyer.
The attorney.
Now, let me ask you this. Does an attorney have to impose laws upon people?
Nope.
Isn't that what he's doing when he files a municipal claim against you?
Yep.
Because that's
Exactly
they
what he's doing.
operate as a summary. That operates as basically, it's considered like a summary judgment filing in a way, because they just automatically grant the lien. So obviously that statute, first of all, he can't impose statutes upon you, but that statute that he's using, that local tax statute, can apply to you for one reason: violates due process of law. Okay, it's right off the bat. You were never served. There's no complaint, and any of your local taxes that are brought against you, here's what they're doing. Here's what you need to separate jurisdiction in your head. It's not an in personam action. In other words, it's not against you, and they'll say it's against your property. Well, that's the most illogical thing I've ever heard. So my property committed a crime, or my okay.
Well,
this is how they're
I
operating.
for one believe your house is very offensive, and
No.
I believe it has committed the crime of unsightliness to the people of the township of Aston. So there you go.
Listen, I know he's got a drinking problem. I'm trying to get him help, but I can't stop him. Guy comes by with a case of beer, he snatches it.
They don't have AA for homes, is what you're saying?
So this dumb in rem stuff, this drove me back to American jurisprudence, and lo and behold, what do I find in American jurisprudence, where it states that here's where your situs comes in. You hear James talk about it. You hear Brandon talk about it. We talk about situs and what a situs actually is. Well, lo and behold, I sort of stumble upon a citation from the court that explains what a situs is. Here's what a situs is. It's determined by what they call the minimum contacts, not contracts, contacts standard, okay? And there's three elements to it. Number one, here's the funny part. When it mentions it, it says it's talking about the entity itself. It talks about itself must be exercising a privilege. Well, I'm not an itself, okay? I'm not an entity. So it's got to be exercising a privilege, okay? The action brought against you has to be due to actions that you're doing in the forum state. So if you're home eating, sleeping, drinking, and what Steve says, monkey business, they are not actions in the forum state. So there's number two. You're not conducting any actions in the forum state. Number three, it states that the acts must be substantial to create a nexus with the state. You eating, sleeping, drinking, and doing whatever is not creating a nexus. Okay? So there's what your situs really comes from. And it states, that same citing states, the location of the property in the state is not enough for in rem or quasi in rem jurisdiction. In other words, just because they claim you're in the state of Louisiana or Utah or Pennsylvania does not matter. You've got to meet that minimum contact standard. Now, how would you meet that minimum contact standard? Well, if you had a business and you registered it with the state, then you'll become a taxpayer, which means you're an entity organized and incorporated under the state statutes and doing business in the state. That would create a situs or a nexus with the state. That would create in rem jurisdiction for the local municipality who's bringing an action against you, because now you're using your property for financial benefit for a business that you registered with the state. You're not using your property for your own business. You've actually went out and registered and what's the first thing you do when you register for a license? You've got to give them a permanent address.
That's right.
That creates the situs, okay? So when you create that permanent address, when you file for that license or you file with the state, that's when you become domiciled in the state under the jurisdiction of the state. It actually states that. when you become you're a creature of the state, when you become an incorporated entity under state statutes, you become domiciled in the state, which means under the jurisdiction of the state. Now, what you're going to find is there's a lot of presumptions going on. They will just cite statutes. The lawyer will cite statutes. Well, we've got a problem here. First of all, nobody from the Township of Aston's coming in stating them statutes apply to me. Nobody from the Pennsylvania Assembly that wrote those statutes is coming in or submitted anything saying that those statutes apply to me. I got one guy determining that, the attorney. So that's what I go after. I say, hey, listen, I don't see any facts on the record like James talking about. He's seen no facts in any case he's got. Same here. So what I did in my last little headbutting thing with the local township, I took a little page out of Steve's book. Steve said, why don't you go file for a summary judgment against him? I said, well, that's a good idea. And how can I do that? Like James talking about and Brandon's talking about. Did that lawyer, remember, nobody from the township came in to testify. The last hearing we had, he had no witnesses. I said, he's got no witnesses here, sir. He can't place any facts on the court record. And and a lot of times the statutes will they initially file as prima facie evidence. Means on the face it might be true. It only stands as prima facie evidence until you challenge it. Once you challenge it, prima facie evidence goes down the crapper. Gone, okay? Mm-hmm. Now we got to deal with affidavits and testimony. We got to get people in here to stand up for this claim. So a lot of what's happening to you with your local county or your local municipalities, presumption. So I always isolate the attorney. What I did in the last filing, I isolated the attorney. And I filed motion for summary judgment. And how did I set that up? In your summary judgment motion, you've got to put a list of undisputed facts in there. Okay, that's part of how to write it. And you've got to write a memorandum of law to support it. So I set it up with a record request. Before there was ever any hearing, I did a record request with the local township, and I asked, provide any record or any legally or lawfully promulgated record that evidences Title 53 applies to myself or my property. And you get the standard response, as Brandon and James will tell you. We did this incredible search, this extensive search, but we couldn't find any records. Great. Thank you very much, So you hit him with that. Provide me any record, or any legally lawfully promulgated record that evidences I'm a taxpayer of the Commonwealth. Because I have the definitions of what a taxpayer is. And instinctively, it'll turn around and say, we have no such records in our possession. Well, great. Because guess what I used when I did my undisputed facts in my motion for summary judgment? The responses from the record request. Hey, I asked these people, do they have any facts that Title 53 applies? They said, we don't have any records. I asked them if they have evidence I'm a taxpayer. They said, well, we don't have no records of that either. Then I asked the killer question, who hired and directed Robert Day, the attorney, to file liens against my property? And what they instinctively say, we have no records of that.
Hey, were you able to find, I'm not going to say a real name here, what Peppermint found in Texas, the 21 days to remove the lien? Did you find that in Pennsylvania also?
That's like, Texas has some really cool laws. That's one of them. I can't find that in Pennsylvania, but we have one similar. It's called theft of immovable property. Okay. And it's anyone exerting any kind of rights against your property for the benefit of another. Isn't that what that attorney's doing? Isn't he placing liens on property he don't own for the benefit of his client? Well, to me, there's no doubt that's theft of immovable property. There's no way it can't be.
And just so everybody knows here, we have a Sixth Circuit ruling on under the takings clause. I just want y'all to know this right here that just happened a couple of weeks ago. While it isn't exactly what I would like to hear from a federal judge, nonetheless, it's the first in a set of rulings where a judge ruled correctly that $20,000 in supposed owed taxes, it doesn't grant the government the right to come in and take a $300,000 home. And as such, they would have to compensate it under the eminent domain clause. This is a step in the right direction. It's not all going to come, the wheels are all going to come off at one time, but nonetheless, say you do owe $20,000. Just hypothetically, how are they coming and steal your whole home and making you destitute and homeless? That's not the purpose of property in the United States.
You're going to love this. Pennsylvania's got a unique process called a writ of cere facie.
Yeah,
what that
we
means
just filed one here. We do too.
Yeah, after there's a judgment, they could file for a writ saying that you've got 10 days to submit an affidavit of defense, or we're going to come in and seize the property. Okay, but here's the problem: clerks don't enter judgments. They can't make judgments. Okay, so no judge has ever seen this stuff. Now here's the great part: I look at Title 53 in Pennsylvania, what they're moving under, and I pull up the actual writ, the wording of the writ. The clerk's signature's there on 53, and it's coming from the president of the court has to sign it. Guess what's missing from the writ that the clerk issues? The judge's signature. Nowhere on the writ is the judge's signature.
Well, this is funny because we'll expound on this too for just a second, because this coincides with James's issue too. All right, so this is for Gary's case against the city of Central for the theft of his motorcycle. So we all know this Title 42, 1983 goes after the professional and individual capacity, right? So we understand this. Everybody grasp this. These are two separate legal entities, people, okay? I just want people to grasp this concept. When you sue them individually and in their office, the city attorney, or say the township attorney, is going to answer the complaint for the official capacities only. All right, it's been 5.5 months. Guess what we haven't gotten a reply from? None of the individuals. Okay? So we sat around and we decided to do the default judgment. Okay. Well, lo and behold, we get a denial. And sitting there looking at it, I'm like, I finally tell Gary, I said, man, this is signed by the clerk. And Gary's like, you're right. It's not signed by a judge. I said, so what does Gary do? Calls the clerk Monday. Ask the clerk, why? How come? So even if you do get a default judgment, like our first one, right? Our first one against the tow truck company, we had to wait 61 days. Then we put the writ of facie in, which is what it's called here in Louisiana, to execute the taking of the property, which is still sitting there for 2 weeks now, by the way. I don't know what the problem is on why the judge has not just rubber stamped that. I don't know. But nonetheless, and the clerk says, well, I've got a reply on the record for so-and-so, so-and-so. That's just their official capacity. That's from one lawyer. What are you doing? So now we're at a stage where we got to figure out how to open that back up, because the clerk is entering in orders and doesn't know the difference between the individual and official capacities for these municipal employees. And I know that you have the same issue on your end now too, right, James?
That's exactly right. Yeah, I don't entirely know the best process, because we've got the issue here in that, well, I guess it depends on the case. I mean, one of the cases I've got going is against some state troopers, and in that instance, we've got a member of our Attorney General's office representing them. However, Utah law only allows them to be represented in their official capacity, but yet he's responded in his motion to dismiss, where he's asserting individual defenses. So one of these things is not like the other here. I mean, we got to figure this out. And so, we're going to be requiring, since these are, dispositive motions, we're going to be requiring an evidentiary hearing. We're going to call it out in that evidentiary hearing. We're going to say, hey, by the way, by what authority do you have to represent these people in their individual capacities? Because when I, as a citizen of this state, if I go to the Attorney General's website and it says, what if I want to find an attorney? No, I can't hire an attorney from the Attorney General's office. I have to go find a private attorney if I wanted that, which I don't. So there you go. But how is it that because Joe Blow, who happens to carry a badge and a gun and who works for a state agency, how is it that he gets free legal services? Because it's not costing him anything. It's costing the taxpayer.
Be a good disincentive for him, wouldn't it? If he had to pay his own legal bills, would it stop him doing a lot of this crap?
You think they would think twice before they do this stuff? They really would. I mean, and isn't that why we're doing what we're doing, is to change behavior?
That's right.
We're not out
And
here trying to rack up. I mean, we're not ambulance chasers, for goodness sakes. We're not trying to rack up money. But that's the only thing that gets these morons to change their freaking ways.
well, and that's it. So the normal man, Tommy Tutu and Susie So, in their little groupthink ideology up there at the local police station, go, hey, y'all see what happened to Johnny? Johnny had to pay $150,000. His wages are garnished. Guess what? Each one of them don't react just as quickly anymore. They'll think their process through. And that's the whole purpose of this next movement, is to get rid of all the immunities, right? It took them 60 years to build up something called qualified immunity and sovereign immunity and all these immunities. And yet when you go back to the Ku Klux Klan Act of 1871, you can see that was the shot across the bow that all the immunities were gone, right?
What's 83 say? Whoever.
Yeah, whoever.
Doesn't say whoever except the judge.
Right.
Says whoever.
Well, West Virginia had a good win the other day. A judge was denied judicial immunity. That was a good big win up in West Virginia. We see Colorado losing qualified immunity. We see qualified immunity going down all across the nation, and it has to. And the reason for that is just like this instance here, where this clerk doesn't know any better. She's working for the federal government at a district court, and she don't know the difference between individual and official capacities. And that's indicative of everything that we do. Right.
That comes down to, like we've talked about before, it's a woeful, inadequate lack of training on their part.
You can get it on every single lawsuit that you file.
You always want to highlight that in your suit, that they're improperly trained. These people are improperly trained, because that puts the county or whoever above them puts them on the hook for this.
That's right.
Yeah.
Every single one of your cases can have an inadequate lack of training for everybody, because every one of you involved in anything that you're doing. Is why we ask you to start with the records request, because it gives you a little bit of confidence moving forward. Not one clerk, not one judge that you send, not one county assessor that you send anything is going to have any answers for you. It's all going to be supposed legal advice, and they have to turn it over to an attorney. That attorney went back to the same idiot colleges that everybody else went to and doesn't know crap from Shinola. So it's a system in place of idiocy. You want to really talk about the system. You want to talk about it. What's really the problem is everybody's idiots. and the few that aren't idiots are surrounded by idiots.
Yeah, writs are, listen, anything I've read in American jurisprudence, writs are judicial, okay? It means it has to come from a judge. It can't come from a clerk. Clerk's not a judge. Clerk might be a court officer, but the clerk's not a judge. Clerk can't handle court. She can't have her own court. The only way a clerk can operate is in administrative capacity. If you bring a contract before the court, okay, you've got a signed contract, and you've got dead set evidence in there that this person's in default. Now that clerk, depending on how the contract's written, there may be what's called a cognitive clause in there. This is most of your mortgages and loans, where you grant the other side what's called a warrant of attorney, which means if there's a dispute between the parties, you waive standard legal process. You give the other side the right to go right to the clerk to execute the contract. But she's only acting like not a judge. She's acting like an administrator. She's executing the terms of the contract that the parties already agreed upon. She has no input into that, okay? She's just doing whatever's on the paper. Brandon's case and James' case, you talk about writs. Well, now we got clerks signing writs. Well, she's not a judge. She can't approve a writ or sign a writ. She don't have any judicial authority to do that. Yet they've sort of conflated this administrative process and this judicial process, and these clerks, like Brandon said, they're improperly trained. These are all ex-attorneys or still attorneys, still holding bar cards, that they don't know the basics of law. They don't know the basic elemental facts of law. It's stunning. When I hand a clerk who's trying to get $50 out of me for paying a filing fee, defend myself, okay, which is a violation of Pennsylvania Article 1, Section 11, because you can't have, you're entitled to due process without sale, denial, or delay. So now you're not going to take my filing unless I pay you this $50 ransom. Then I went and found that the rule to go with that, it's like Rule 205 or something in Pennsylvania, it states if the summary judgment motion adheres to the rules of civil procedure, it must be accepted. Nothing about must pay $50, must pay a fee. If it meets the rules of civil procedure, it must be affected. So now I asked the clerk, you operating under? Show me the law that says I got to pay to defend myself. These are just our rules. Oh, they're your rules. Where do your rules supersede the state constitution and the state rules of what's acceptable as a filing? So these are mistrained people that have been getting away with doing this stuff for years, maybe decades, okay? And it's called customs, practices, and policies. These are not laws they're operating under. They're customs, practices, and policies of how they operate. And this is what makes them so easy to set up, because they don't know the law. And when you get them in a lawsuit, there ain't no way they're going to be able to sit in a deposition with you and answer questions. Not going to work.
Well, then we can just do this simple analogy for everybody listening and everybody who listened earlier. There's absolutely no way that these corporations, these local governments would have put themselves under so much heat and under so much liability if they were even remotely aware of what they were doing during COVID-19. Even remotely. You understand? And this includes the attorneys working for these corporations that were telling them, oh, yeah, this is lawful. Yeah. How many attorneys did you hear say that? This is completely lawful.
Oh, yeah.
I
have that in court filings.
Yeah.
These mandates are not unconstitutional. Really?
That's right. So we have to understand that we have to grasp this totality and this truth that, yes, we really are and have been dumbed down this far. And yes, while the people are corrupt, but that's the ignorance of people, right? When you really don't have any idea of anything else other than material things, right? So if you wave pretty shiny little things in front of somebody that has no core beliefs or tenets and is soulless, guess what they're going to do, folks? They're going to rip you to shreds. They don't care about you. And that's just human nature. So until we get the rule of law back and there's consequences for these criminals getting into these positions, hey, listen, this is the fact of the matter. So what's the purpose of everything that we do? Hey, just leave me alone, right? Yeah. You want to be a criminal? You want to do whatever you want to do? That's fine. Just leave me alone. But the only way that you can do that is fight back, and fight back without a sword, but do it with the pen. And the more that I fight back with this pen, and you guys know this, the more it opens up just the overall incompetence and ignorance at all levels of this society is what you're dealing with. And those few times that you talk to somebody with a little bit of sense, it's like, oh yeah, we're not all stupid. Oh, what happened?
We lost James.
Lost him. Okay. Well, he clicked out, I bet you. So,
and another thing, like that they sit on the property tax stuff, because I know that's important to a lot of people. What you want to do is, it's funny how, when you read stuff, it just jumps out at you. It's amazing how many people don't read things. And when I read the Assessment Act for the municipalities, like the county here, it states that here's what they want to do. They want to try and look at Brandon's house and go, well, Brandon's house is worth $375,000. We're going to tax it on $375,000, okay? What is the problem with that? First, Brandon has a right to own the house. So what they're trying to say is they're going to tax Brandon's right to own the property, which is an impossibility. So the way these valuations are really supposed to work is there's three elements to these assessments of property. One is what Brandon's property would sell in the open market, about an estimate. And they could say, hey, well, these properties in Brandon's neighborhood going for about $375,000. Okay, that's element one. Element two is replacement costs and depreciation. Hey, Brandon, do you depreciate your property each year? Do you depreciate equipment? Do you depreciate your TV and your stove and your heater? Do you depreciate these each year, Brandon?
No.
Okay, so there's number two. That's element number two, and arriving at that actual value. Here, number three, Brandon. Are you generating income from your property there, Brandon?
I'm not.
Okay, so there's element number three. Now it states that all three elements must go into determining actual value. Well, obviously, if those three elements appear and two of them, there's no way they can apply to Brandon. And he could even argue that number one doesn't apply because They have no right to determine what Brandon would take for his property. They can't look at someone, Brandon's choice what he can take. Brandon would say, I want $500,000 for my property. I'm not taking $375,000. So they have no way to square those three elements because Brandon don't depreciate his equipment and his property and replacement value. And Brandon's he have no income from the property. So how can they arrive at an actual value for Brandon's property? So
give me one second because I want to go ahead and talk to this guy. Hey, look now.
There's no amnesty law.
Spell we're correct. Come on, people.
Come
this
on,
is not hard.
You're not lost at sea. Your mom's lost at sea. That's just lost at sea. Your mom's lost at sea. There's no lost at sea. Come on.
Go find them. Good heavens.
So look, this is an indoctrinated and programmed mindset that you have here, right? When you get back to land, what are you going to do with it? Like this is the defeatist. This is the defeatist mindset that you've been taught, where you're going to sit on your thumbs and dum-dums, sitting on waiting on somebody else to do it for you. Hey, listen, we're activists, we're involved, and we just today a little lady won in small claims court.
Yeah,
you know what? It happens every single doggone week that we get somebody coming back and saying, thank you. I won my case. And yes, there's ones that lose them. It's going to happen. But nonetheless, we're arming people with the correct knowledge of how to navigate this system of American jurisprudence that can be fact-checked objectively, found in the rules, not some crap about being lost at sea and how to get back on land. You're off in the weeds. You post something else like that, you're out of here.
Yeah, I mean, listen, it's really no more complicated than, like we were just talking about, incompetent people doing things they're not supposed to be doing, okay? It's really no more complicated than that. They're not following the actual laws. And like Steve says, that's what makes them so easy to set up. Because, listen, like Steve said, this is code pleading, whether you like it or not. It's code pleading. You got to read the code and the statutes. Because that's what you stick up their rear end. That's what you get them with. Hey, listen, the code says this, but you're not doing that. You're doing this.
You're not doing it.
They can't answer that. That's why Brandon's guy is over there looking at his YouTube videos and talking about his philosophy, because he's sticking to the law and the facts in his pleading, and the attorney's going, well, I can't answer that because I can't. Okay, let me go talk about his YouTube video and what he said about the judge. What he said about this. He's outside the pleading because he can't answer what is in the pleading.
And look, and while we're talking about that, Rule 610, go ahead, keep on going. Rules of evidence. Let's just look at this together. All right. So just so y'all know this, the federal rules of evidence are pretty powerful, and we need to learn these things. Okay. My ideological views. Right, your ideological views are protected under the First Amendment, right?
Yeah.
You get to think and act independently of anyone else, period. That is your freedom of conscience, okay? As long as my freedom of conscience doesn't violate the life, liberty, or property of someone else, it doesn't matter what I think. It doesn't matter what you think. You cannot take my YouTube videos, go and put them into the court evidence and attack them because it's a violation right here. You see this? It's inadmissible evidence. This is in violation of Rule 901, Federal Rules of Evidence. And it's inadmissible evidence, okay? It's inadmissible. And so once you grasp the ease of this, and this is the purpose of us, showing you the rules. Do rule. Yes, you're going to have bad judges. You're going to have bad lawyers along the way, but eventually what you're going to have is an adult somewhere. And it's probably, it may be at your trial court. It may be at the appellate court. It may be at the Supreme Court. Wherever it is, these rules that are constantly broken by the opposing counsel is going to eventually get to the point where they have no way to go. So we have a rule violation of 803, 901, and 610 by the attorney. That's not counting the harassment, frivolous pleadings, and also the libel committed against a third-party attorney. A completely innocent bystander, by the way. Nobody's writing my complaints. Where he decided to throw that in a pleading, which is a materially false statement made to a third party also, right? That's in Rule 11, by the way. That's Rule 11 sanctioned. So when you grasp why the rules are there and they're good and just, it's just that the people are perverting them. Well, if you stand by them and you actually hold them accountable, that's the purpose of the code pleading that Alphonse is talking about. They are so far outside their office. Okay, so their office, the codes, the statutes for the creatures of state, which keep this in circle, put them in statutory bounds. That's what that means, statutory bounds, right? It's the completion of their office. Anytime they come outside that office, they're acting in their what? Individual capacity. They broke the bounds of their. That's why even the Choctaw Indians lawsuit is in the official and individual capacity. Okay, why is it the official? Well, the tribal chief passed an ordinance, a corporate bylaw, right, stating that scarves, bandanas, and other suitable fabrics must be worn by all people, right? Well, first off, that's not medical. That's just a religious belief. Whatever it is, you want to don your rights of subservience to your branch Covidian God. That's by all means do it, but it can't be considered any medical device. Second, so that's the first thing. He passed the edict. That's in his office. But he stepped outside of their bounds by violating Title 18, Section 1302, which restricts their rulemaking. So once you grasp this and then you get into court and you take the rules and you circle them with honor, integrity, and truth, and you just keep closing the doors. And that's the purpose of this particular episode, is to show you how far they'll go to slinging mud and crap up against the walls to try to get something to stick.
Oh, man. It's bad. And if I can just show you guys again here real quick, not to get you off the topic you're talking about, but just how bad these things get. So let me go back to where I was at here. Sorry. So real quick, I'm going to present my screen if you don't mind.
Go ahead.
So again, we're going to talk about Rule 12. Let's look at Rule 12G, joining motions, Rule 12G2, limitation on further motions. So we've talked about this a little bit, except as provided in Rule H2, which is right here. A party that makes a motion under this rule must not make another motion under this rule raising a defense or objection that was available to the party but omitted from its earlier motion. All right, so keep that in the back of your mind. Now, I'm going to show you here on the left side of the screen is the first motion to dismiss that these idiots filed. And we have all of their claims right here. On the right side of my screen is the most recent one they filed. Okay. So right here, you've got 1, 2, 3, 4. 4 defenses on the right. So that's the most recent. The first one was 1, 2, 3. All right, so now we already know one of these things is not like the other.
Right.
Okay. So then it's just as simple as going through and taking your highlighter. I wish I could, because this is a hyperlinked document, but you're just going back and forth. All right. So right here, it says the First Amendment claim. Well, I don't see that over here in the first motion. So guess what? That's waived. The class of one claim. I don't see that over here either. That's waived. The Sixth Amendment claim.
That's waived.
That's waived. Brown's claim for equitable relief. All right. Do we see that here? Oh, hey, that's there. Okay, that can stay, so to speak. But here's the thing, guys. The courts don't look at this document on each one of these little claims. They look at it as a whole. If the document contains one or more defenses that were waived, the court cannot consider the entire document.
Huh.
Okay.
That's a pretty big thing, James.
Keep that in mind, you guys. This is the power that we have. And see, these stupid liars, they're just dumb enough not to know this, or they're just going through the motions. Oh, it's just another motion to dismiss. We'll go back and forth, back and forth, back and forth. Why don't they do any of these things? Again, when you look at the rules of evidence, when you look at the rules of procedure, the court does not pick and choose. They're not going to go, well, this claim, this claim, this claim, this claim. They will in your complaint, but they're not going to do that in a motion to dismiss. And especially if your complaint contains some other type of cause of action, like a declaratory judgment or an injunction of some kind.
And you know what's crazy, though? Because I want to bring this up, too, because this makes total sense, because we filed this inside of Gary's motion for summary judgment, and because of the attorney waiving the statute of limitations. But either way, this language is still, this fits what you learned in Dr. Graves' course, by the way, that a defense waived or not, or originally, what's the word I'm looking for here, James?
Not answered.
Well, that's right. Not initially pled is waived for all intents and purposes. So this is a very good find in the rules, by the way, James. Thank you.
Yeah. Well, I mean, it just goes to show. I was sitting here beating my head against the wall last night, because I mean, you saw this complaint that these motions were filed under, and no one with a brain in their head can look at the evidence that I've included with the complaint that's part of the four corners of the complaint and go, wow, there's no way this guy doesn't have a claim for relief. Okay. Now, what this stupid liar is trying to do is, when he submitted that original motion, he submitted as supporting documentation a link to body camera footage from the officers. But guess what? That's not authenticated evidence. Right. It's not really available in some public forum. It must have the court. I mean, when you read the rules of evidence, it says it must be certified, must be verified, and it wasn't verified. And so now they're making reference to those body-worn footage camera again in this most recent one. Okay, so now either
is it all raw footage, or was it edited? Did they edit it? You don't know what they did.
Who knows? That's what we don't know. We don't know if it's raw footage, if they've edited it, if they've broken it down. And see, my day job, I sell software that they can do that, where they can edit that footage. They can block people's faces out. They can do stuff like that. So we don't know if it's raw footage. We don't know if it's, and so we didn't. I specifically left the reference to body camera footage out. Specifically, I only wanted stuff that we could allege and that we could prove, which we did through public, through the cell phone video that's posted publicly by my buddy, and then also the other bystanders. So now I got a multiple of issues with this stupid liar going, dude, you're doing nothing but wasting people's time, and you've committed sanctionable offenses.
Well, and I think that's the purpose of it too, because we have to look at the flip side of this also, James. And the more we go back and look at the 40 different filings in my case, we have to understand that we've set up a system, or a mindset, really, not a system, where lawyers get billable hours, and that's all they really care about, right? As long as they're writing, they're getting billable hours. What else does it matter? Yeah. But again, that's our fault too, right? Because we know just getting billable hours is actually delaying the proceedings. That's what it is, and it's meant to harass people.
And that is a violation of Rule 11.
That's right.
And it's clear as day that that's what's going on here. So, I mean, we're gonna politely point this out to this liar. I mean, the court likes to see. They like to see you guys try to work out this stuff without getting the court involved. They don't want you to just file motions for sanctions right off the bat. Say, try to work this out. So we'll give the guy the benefit of the doubt as a professional courtesy. We'll send him an email tomorrow and just say, hey, had a chance to review this. There's a number of issues, and just list out those issues and say, what do you intend on doing with this? You want to stay the course? You plan on just going this route, or do you want to be the grown-up in the room and go back to your clients and say, we don't have a leg to stand on. We need to talk to these guys about figuring out how much it's going to take to make them go away. And we'll see what they say.
Like Brandon was talking about, eventually you're going to hit an adult. And now listen, I've done record requests here and done appeals and record requests. I've even have attorneys now turn it against other attorneys. The appeals attorney turn it against the municipality's attorney by stating things when we asked for records of the code enforcer, his contract, and his agreement. We wanted all employment information on him. The Borough of Upland said, we don't have any such records, which led the appeals officer to say, it defies logic that you don't have records on an employee. And he said, it's incredulous that you would not have records on a code enforcement officer, okay?
Yeah, that was, I never laughed so hard when I saw that. That's hilarious.
That's another attorney. Listen, they're looking at this and going, you know what? This guy's right. This guy's right. Look at the crap they're doing. And another appeal, which I stick in their face every time I do a record request. She stated, here's what they request. And here's what they'll hide behind. If it's not an exact record that they keep, that they already have, they say, well, under the record request law, we don't have to provide anything we don't have, okay? But that's really not how the record request law is written. The record request law is written as any kind of information also, regardless of form, can be a record. So when I ask for basic stuff from the sewer authority and attorney, there's another attorney now, appeals officer said, it defies logic that a request for records is by definition a request for information. Mr. Faggiolo's asked for information. He wants to know how his property got on the customer roll. You know, it doesn't matter. Somebody should be there to be able to explain that. So now this is just in a little record request. Eventually, here's what's going to happen with judges, adults. See that federal judge? He's not an elected judge. These little local municipal judges, they're elected judges, these guys, okay? Listen, he ain't going to throw his career away for some dummy down in the county or the municipality that's doing what he's not supposed to be doing. And he's not going to make himself look bad, that judge. So eventually it's going to hit a judge or appeals officer, appeals judge in the state, or it's going to hit a federal judge. He's not going to risk getting thrown under the bus with the idiot that did a bunch of crap he's not supposed to be doing, like claiming he has in rem jurisdiction over your property because the statute said so. They're not going to do that. They're eventually going to say, I can't go along with you on this, because you're not going to be able to defend this. This guy takes you to court and sues you. You're not going to be able to defend this and come in and explain how the hell you did this. So eventually you are going to hit an adult throughout and that's why we make our record. Listen, James files things and Brandon files things, and we know they're going to get shot down. We know it right off the bat. As we're filing them, we know they're going to get shot down. All we're doing is making a record. We're just making a record to show that, no, look, we addressed that. They ignored it, or they decided they didn't have to address it. So then we sue them later. We're going to bring all that stuff back in and go, hey, you sent a record request asking who hired this guy to do this. The borough told me they don't know who hired him. So evidently I got an attorney acting rogue running around filing liens on property he don't own. Pretty sure that's a crime. But not only is it happening to me in my federal suit, it's happening on a grand scale throughout Delaware County. This is federal racketeering. This is the definition of federal racketeering. There's nobody, these attorneys are running around here like freaking gangsters, just doing stuff, and nobody's keeping them in check, especially the municipal courts. And that's their job. These judges are supposed to keep these by the rules, they're supposed to keep the attorneys in check. You don't let attorneys speak without personal knowledge. I brought it up in my one last hearing. He's got no witnesses here. Objection. He's got parole 602. He's testifying. No, he's just giving me information. No. He's opening his mouth. He is testifying against me. Listen, stick to the rules. Don't get depressed when you file in these local courts that your stuff's going to get shot down. And I'm stunned we win as much as we do. Like we just had the woman today had another win. Okay, listen. Every week we have multiple wins. I'm stunned that we win as much as we do down here, because I've seen it. I mean, probably out of 10 things we file, one might go our way for somebody. That's just the nature of the business as far as for the municipal courts. You need to realize that all you're doing is, even though your stuff gets shot down at the lower court, doesn't matter. You're just making your case for the appeals court or for the federal court. That's all you're doing.
Well, you know what? And real quick too, Alphonse, even the federal courts, the federal district courts, it's hard to find an adult in the room. I'm finding this is painfully evident in the cases I'm litigating, especially since the majority of, not the majority, all of these dispositive motions, motions seeking dismissal, that's all a dispositive means, they're all being referred to magistrate judges for them to comb through and issue a report and recommendation. See, this is the problem with this. We never consented to a magistrate judge because that's not a judge of an Article III court according to the Constitution.
Right.
They're there basically to be the peons. And I hate to use that term, but I don't know a better term. They're there to be the peons in the courts to do all of the busy work, so to speak, for these district court judges. So now when they issue that report and it's chock full of crap, or they're not, clearly erroneous applications of the law, clearly erroneous applications of the court rules. Now I have to take the time to issue an opposition to that report, something I never should have had to do, but that's where we are.
All right. So I want to discuss the Sixth Circuit ruling here. And then I want to discuss a couple nonprofit attorney organizations that I've started following. And I'll discuss this because I want people. We'll talk about the bad, but let's talk about the good too. Let's read this ruling here. The U.S. Court of Appeals for the Sixth Circuit released a potentially important decision concluding that a Michigan county overreached when it seized an individual's property to satisfy a tax debt and did not refund the surplus to the property owner. Judge Cathledge wrote for the court in Hall v. Meisner. In this case, the defendant, Oakland County, took absolute title to plaintiff Tawanda Hall's home, worth close to $300,000 on the facts alleged here, to satisfy a $22,000 tax debt, and then refused to refund any of the difference. The other plaintiffs shared a similar fate with their homes. Under Michigan law and the law of virtually every state for the past 200 years, a creditor, understand that word, can divest a debtor of real property only after a public foreclosure sale, after which any surplus proceeds in excess of debt are refunded to the debtor. The return of that surplus compensates the debtor for her equitable interest in the property, which in common speech is called the equity in real property, and which English and American courts for centuries have called equitable title. Yet the Michigan General Property Tax Act created an exception to this rule for just a single creditor. Let me tell each and every one of you that every single one of your local municipalities has created the same rule, okay? It's going to be named something different. Namely, the state itself or county thereof. They're giving you the clues here, folks, that local government is your issue, okay? Pay attention. Which alone, among all creditors, may take. Here's the problem with this speak right here. Did the county or the state loan you the money to get the house?
No.
Okay.
And the bottom line is, do they have ownership, interest, or taxable interest in the property?
They do not.
No. Yeah.
So namely, this is good stuff here. Which alone among all creditors may take landowner's equitable title without paying for it. When it collects a tax debt, in that respect, the Michigan statute is not only self-dealing, it is also an aberration from some 300 years of what's called jurisprudence here in this United States.
Let me insert this real quick.
Wait a second.
Because me and Steve have talked about this. Listen, here's how actual tax debts work. Say I'm a business and I owe $10,000 of debt, okay? The county could come in and seize $10,000 worth of my equipment or my property, whatever I have, and sell it to satisfy the tax debt, okay? They can't sell my property, though. Only the title holder can sell the property. They can't sell the property. So for the common man who they could say owns a $10,000 tax debt, what are you going to do? Come and sell four square foot of my property in the front? My front lawn, they're going to square 4x4. Mr. Faggiolo, 713 Lampus Lane, you can own 4x4 for $10,000, No, those tax laws weren't written for us. They were written for seizure of property of a business that actually has a real tax debt, not you or I. And that's really what that case is saying right there. It is. And listen, that's a very common practice. They will sell the whole $300,000 property for a $7,000 tax debt and keep the money without returning it to the people. And sometimes they'll return it only if you request it.
That's right.
Well, most people don't know that.
Well, and we'll complete here, and then. But what I want to do is show people how and I'll talk about this, right? Because the pendulum swung, right? And from the 1930s forward, the pendulum swung where we lost individual liberties, and it's crescendoed, guys. It's reached the point of where the common everyday people, me, you, James, and Alphonse, have said what? That's enough. We've had it. You're not going to continue taking my individual liberties without. There's two options here at each of these pendulum swings back down. There's either bloodshed or return to the rule of law. Okay, that's the only two. That's the only two ways it goes about it. And we've reached that morally decadent point where the idiots are starting to consume themselves and their lunacy. Right. So, although it always seems darkest right before the dawn. The dawn is here, folks. COVID-19 was designed to bring us into complete communism. It failed. Quit being in that mindset that you can't do anything. Yes, you can. The only thing that you have to do is get up off your bum and not expect somebody else to do it. Find the perseverance and the tenacity to go after this stuff, because there's no better time. Even in Steve's days 20 years ago when Steve was doing it by himself, there's no better time to get to these courses than right now.
Yep.
All right.
So here's something I'll just throw in real quick in regards to the whole property tax thing. So read your state constitution closely, because that's what these states are going off of. And I'm willing to bet that every single state has something in its state constitution in regards to property tax. And I'll read to you real quick what here in Utah, what it says. This is under the revenue and taxation article of our state constitution. And this is what it says under the number 1 line. It says, so that each person and corporation pays a tax in proportion to the fair market value of his, her, or its tangible property. All tangible property in the state that is not exempt under the laws of the United States or under this Constitution shall be, and then it talks about the tax assessed. So I've got a few questions here. What constitutes tangible property?
It's got to move.
You got to pay a tax on your CD player, James. Your TV, your CD player. You got to pay tax. It's tangible property, isn't it?
We know what the intention of the writers of that, though, is going to be things moving in commerce. That's going to be tangible property, right?
Exactly.
That's on 18-wheelers. That's on rail cars. That's on whatever aspect is going to be the original interpretation of that design.
So you mean to tell me there, Brandon, that my house that is stuck in the ground and doesn't move, that's not tangible property?
That's not tangible property. That's immovable.
Okay, cool. Good to know.
That's why Pennsylvania's nice. They have theft of property, and they have theft of immovable property, and that's what your house is. It's immovable property.
Yeah,
you might have a similar. I don't know, Utah. You got to check. You might have a similar statute.
I'm sure we do, but that's what I'm saying. You need to read. You need to read this stuff, people. You need to read your state constitution. You need to know it inside and out, because within our same constitution, the very first article is our Declaration of Rights. And it talks about how we each have a right to acquire and possess property. It doesn't say tangible property. It doesn't say immovable property. It says property. So it's all.
Doesn't say real estate. I don't see real estate anywhere in there either.
It's all.
Anytime I see real estate mentioned, they're talking about tenants. And when you read the cases, it's somebody he's got commercial buildings and he's renting property out and he's got tenants. That's what real estate is. The developers have real estate. People that buy property and rent it out, they have real estate. You and I don't have real estate under the definition of real estate. And that's a term that they try and bullshit everybody with, that you have real estate. No, you don't. You have property. Go show me real estate in the Constitution. I can't. It doesn't say I have a right to acquire, possess, and protect real estate. It says I have a right to acquire, possess, and protect property. Period. That's it.
That's why you gotta read stuff, guys. You just need to know and understand what this stuff means. And so what your counties are doing, what your cities are doing, and what your townships, your boroughs, wherever it is that you live in this great nation that we call United States, what they're doing is they're looking at that going, oh, okay, then that means we can tax your home. We can tax your personal property. Well, hold on a second here. The way I'm reading this, tangible property, all tangible property. Okay, so I have my desktop computer.
Your oven.
Right? So I got my desktop computer that I'm doing this broadcast on right now. It's worth today maybe $800. So it says here that I should be taxed 0.005% of its fair market value. I mean, what's the math on that? 25 cents?
And y'all keep talking. I'm just answering questions as we're moving forward. And injunctive relief or equity. All right. So let me answer this question from the tribe. Okay. You can merge. You can do both equity and law in a pleading ever since 1938.
Yep.
Okay.
I've never seen pleading that's not the same, that have the same things in them.
That's right. So the matter of law must be ruled on by a judge. Okay. And let me give you an example. I'll give you an example from one of my complaints. I have the constitutional strict scrutiny rule, rational basis review inside my first cause of action against the tribe. Okay. That is a matter of law. That's going to be ruled on by the judge because it's equitable. It means it applies to everyone. The second cause of action goes into law. And so you can merge the two together. You can get injunctive or declaratory relief inside the same pleading that you're suing them civilly. Mm-hmm. I hope that kind of explained that for you. You can merge both of them into the same pleading now since 1938. So I hope that helps you. And then we'll move on and finish this what Judge Cathledge had to say. And so understand this, folks. It's underneath your takings clause, which is called the eminent domain. The government can't come and take your property without just compensation, okay? The government may not decline to recognize long-established interests in property as a device to take them. That was the effect of the Michigan Act as applied to the plaintiffs here. And we agree with the plaintiffs that on the facts alleged here, the county took their property without just compensation. We therefore reverse the district court's dismissal of their claim against the county under the takings clause of the United States Constitution. So we'll see.
Sixth Circuit. Boom.
So this is the Pacific Legal Foundation, and I want to give these people a shout out because I've already researched them and the Institute for Justice.
Mm-hmm.
Institute for Justice. Let me find them real quick. This is another nonprofit, and their entire gist is to get rid of qualified immunity. Good. That's it. This Pacific Legal Foundation, and I just want to tell the truth here, guys. So when I was doing my motion to show cause for why the attorney should be in contempt, I ended up on their website, and I started pulling some of their stuff, some of their pleadings, some of their motions, and I started reading them. It's great stuff. And the same thing over here with this Institute of Justice right here, who are single-handedly going. There are good people, okay? There are good people out there who've had enough. So don't just focus on the bad. Here's another case where what Alphonse has been screaming for the last 2.5 years, if not longer. This is a fact, folks. They are stealing our property for profit. Mm-hmm. Period. Period. That's it. Any logical thinking man or woman would go that this is a taking. If I leave you homeless and destitute, that is taking.
Like Steve said, think about the logic of this. You would have to believe people said, hey, let's set this system of government up so that they can come take our homes and sell them and leave me homeless, destitute, and bankrupt. You would have to believe the people said, yeah, let's set that up. Bullshit. They didn't set it up that way. You just have people that are not following the actual laws as they're written. The problem you need to get in your head is if you're fighting the locals in the local courts, you're not going to win down here. It's not going to happen. We're going to railroad you. Every now and then we get like a win like today. Every now and then we get one of them through. But you need to understand that I'm going to have to get into federal district court where these people don't have any friends, where it's not the old boys network. Even though like James runs into some judges, you don't know what judge, and you don't know that's a coin toss too, but you have a much better chance up in the district court. And even if James loses a case here or there, guess what? Just him bringing that suit against them will make the locals take pause to bother that person again, because they know this man and sue me. So they're not an easy target. They know even though we won, they did sue and that cost us money. They don't want to try it again because James may bring the same suit in again under something else, and maybe he gets a different judge in there, and it gets handled differently. The suit goes differently, and then they have a danger of James setting a precedent by getting a judgment against them. So he gets a judgment against them, then everybody in the county where James lives, where that person lives that James helped, they can now use that pleading and go, hey, I'm going to need you to do that for me too. And that's what generally drives them to the settlement table, early settlement table, to make James go away. And let me clarify this too. Like people ask, well, what case number is it? I just won a case for a guy, and it had to do with an estate. He got a $300,000 settlement. They actually had him kicked out of the will. We challenged the will the very last day, and we got a settlement at $300,000 he walked with. You're not going to find that case number anywhere, okay? It goes off into the ether, okay? He's a disclosure agreement to get the money, and sure, the NDA includes, well, you won't sue us for this, and you won't sue us for that, but this went on for 2 years, and he was exhausted going through this stuff. So the $300,000 sounded like a good number. I told him, take the money, but you're not going to find that case sitting anywhere, okay?
Nope.
And you're not going to be able to find he can't even give you his documents because now he signed a non-disclosure agreement. He can't provide you his documents. So don't think because you're not finding cases that there's not settlements out there, that there's people not doing this. You're just not going to see it. They can't have that out there. They can't have, if James wins a suit or Brandon wins a suit, they can't have it sitting out there for the monkeys to come copy. So they're going to make it go away with a non-disclosure agreement. And listen, I encourage people, if the money's right, take it. Go live your life, you don't have to be a warrior and, I'm going to save the world. Take the money and go help your family, help yourself.
Yeah. Yep. That's totally true. I mean, that's why I say, that's why we do this, right? We do this because, we want a change in behavior. Number one, we want to be compensated for our damages, for our pain and our suffering we had to go through. I mean, I can't tell you as a parent, as a father of children who would come home every single day in tears going, why do I have to do this? This doesn't make sense. I mean, when your 5-year-old son comes home and is like, this doesn't make sense. I mean, something's wrong here. And Brandon's right. I mean, this was the next step to push us towards communism. That's what it was. I mean, they did the first 2 steps way back in 1913 with the creation of a central bank and with the progressive income tax. Look at the Communist Manifesto. It's right there. Right there. Right.
To remove
it's there. So we the people have to start standing up. And I feel terrible it's taken me this long to wake up. And you don't know what you don't know. But now you do. Now you people know. We're educating you. Others are educating you. There's another great website that I wanted to point you to that, Brandon, you were talking about. I dropped it in the private chat there if you want to throw it up on the screen. It's in our private chat.
Oh, we got a private chat? I didn't know we had that.
Yeah, we do. Yep, that's so I can talk to you guys and everybody else can't see. But throw that website up on the screen there. Go up to the top of the screen there. So I was on the SGT report, as a lot of you guys know, with an attorney, Todd Callender. He's one of the good guys. They're very few and far between, but he's one of the good guys. They created this website here, 5 Small Stones, and there's complaints here. There's actions here. If you scroll down a little bit more, he talks about the steps you can take. That video that I did with him is right there. Pro se discussed. So we talk about, what we're doing. He's got links to all of our stuff here.
And while we're here, let me go ahead and do this. So, all right, let me put this up.
Let me real quick. You got a guy posting in here, and he's all on the post office and everything's a trust. No, listen, guys, get away from that stuff. That is not going to help you. Okay, the trust stuff and the post office. Know what the post office does? They deliver your friggin' mail. That's what the post office does. They're not a court. They don't own anything. Okay, stop with that postal stuff. And not everything's a trust. That's not how trusts work. You first go understand the basics of trust law before you want to tell everybody that everything's a trust. Because evidently you don't even know what the basic elements of a trust are.
No, nobody seems to know.
I want to talk about this because this is going to go towards and the only reason I'm showing this is because you guys that are in here and that are going to be following, I am currently writing the next lawsuit. I've shared 2 drafts already. This of course is just a draft. It's going to continue moving forward, but this is going to be against the hospital for my daughter. Okay. And what you'll see here, I'm taking off work tomorrow and Friday. This has to be filed before November 18th because the 1-year statute of limitations is up in Louisiana. But for those of you out there who have issues where your rights were violated due to employment, this is going to be the perfect, simple. So this is not going to be, let me state this. This is not going to be as complex as my Choctaw Indians lawsuit was. This is a very simple, straightforward. You'll see here I've already got the right to sue from the EEOC. We have emergency use authorized drugs that were used and people were forced to take, right? Or were legally coerced, put under duress, emotionally, psychologically, and physically traumatized, threatened, and blackmailed to either take the jab or lose their jobs. Hey, folks, this hospital has zero protection at this point in time. You see, even New York State right now is falling apart with their bull crap over this stuff. These were not authorized drugs. The media, the politicians, and the corporations all lied to the people over this stuff about being authorized. And now you have Pfizer coming out and of course admitting, yes, it doesn't stop transmission or whatever. It doesn't matter. The farce is over. It is the time to go follow along as I write this complaint, because there's going to be about 6 drafts by the time I'm done, and you'll be able to follow it very simply and just plug and play your issues for when you were fired or harassed or threatened or put under duress or emotionally traumatized, right? And use it. I know there's a bunch of you out there that are following it too. So I just wanted to say that, and I'm going to let James finish up on the 5 small stones.
Yeah, that's all I wanted to say is there are people out there that are giving you the tools you need to be successful. So right now, people, you have no excuse, none whatsoever, for not taking action. You may not have confidence, and that's okay. It's okay not to have confidence. It's okay to feel nervous, or heck, it's all right to even feel scared. I mean, it's it's unknown territory for a lot of people. I mean, I've never litigated in court before. I've never litigated in federal court. I mean, I've been in small claims court, but this is before I knew any better, and I had a lawyer representing me. So, it's not as difficult as it seems, as long as you know facts, you know the law, and the facts and the law on your side. Even if you don't get the remedy you're looking for at the district court level, federal or state, it doesn't matter. The grown-ups in the room are at the appellate court level. Read the decisions. It's there. And you'll get your remedy. It might take a while, but you'll get your remedy. And again, don't be afraid with these guys. They're going to put up a fight. They're going to throw crap up against the wall and hope it sticks. So they are going to put up a fight, and just stand true, stand firm, and you guys are going to be just fine.
Make space heaven again. Look, I appreciate your zeal and everything else, but listen, if you want to go scream and cry in a corner about how you've already lost and go face down, ass up, go ahead. That's your prerogative, okay? Ain't no quitting me. I ain't lost nothing, but I'm not going to put up with that type of mentality in here. I'm just telling you right now, if that's all you want to talk about and wag your own tail about how bad it is, this is not going to work.
Nope.
Okay, not going to work. Not in here. Thank you. Yeah. Where do I even have a moderator in here today? I don't think I do.
I don't think so.
I don't think Ange is usually here. I'll take care of that. I'm about to put somebody as a moderator. No, the tribe's a moderator. I got them. Okay, y'all guys block the perverts. That's all I want y'all to do.
That's the other podcast, not this one.
Yeah. I'm sorry. I'm not twerking on here. Alphonse, hey, listen. I'm just telling y'all right now. Alphonse might do a TikTok video later, twerking with the long hair flow.
I'm not even sure what TikTok is, actually. I know it's some kind of internet app. That's about it.
you got the gray locks going, bro. Just turn your fan on.
I got to do a dye job. I got to get a dye job going.
Hey guys, this has been a lot of fun. I got to take off. I got to get my kids dinner, as you guys can probably hear in the background. So thanks so much. I've really enjoyed this. And again, let's do this again soon. I want to keep people updated on our cases, what's going on. But above all, guys, just read the rules. Read them, know them, search the appellate case law that applies to the case, and force it on them. Make them prove it up.
We have to remove ourselves from this victim type mentality. Woe is me. I can't do nothing. That's just not going to solve anything, folks. You know the problem. Become the solution instead of just constantly making excuses. One of your guys in your chat today, I got a job. I got kids. Well, yeah, me too. James too. I mean, what are you talking about? I mean, you just put in some effort. I agree. And James will catch you on the flip side. Look, now that y'all see how crazy the flurry of motions was on my side, dude. It has been ridiculous. It got me to the point where I was really burdened over it all. Well, there he goes. But nonetheless, I don't know if he did that on purpose or not. I was talking to you, James. That hurts my feelings.
Yeah, it's a war of attrition to wear you down. They're trying to wear you down. That's all.
Well, that's right. So I had to take a little break too, right, and refocus my mind and just know, guys, we're telling you what's coming down the pipeline. Alphonse has been dealing with the local kangaroo crap for, what is it, a year and a half now?
Since 2019, I've been fighting with them.
Yeah, that's what I'm saying. I share my drafts on Telegram, guys. On the Telegram, come to the Telegram. I think I put it in your group too, huh, Alphonse?
Yeah, I put them in yours, and we share them among the groups.
So this one is going to have tomorrow. I'll work on it. I'll get the 5 causes of action. I'm going to keep it simple, and I'll tell you why. If you're helping somebody, okay, like I'm going to be helping my daughter in this as special counsel, right? Writing the drafts. Can I teach her 10 to 15 different causes of action at one time? Probably not. She's probably not going to retain it. So I'm going to make this very simple. I'm going to make this the simplest of all my complaints so far. And I think on the flip side, I'll be able to help more people, because people go and read the Choctaw Indian case and think they can copy that complaint. And you just can't, because it's not even apples to oranges. You can't do it.
And that's what people don't understand is they just because suit written a certain way, you just can't erase the name and put your name in there and it's going to be the same suit. It's a different set of facts. They've had different interactions with these people. They've done different things. So you actually understand. You have to understand the rules, the law, and the cause of action that you're filing, so that you know that you've got the proper elements. Each cause of action has specific elements that need to be pled. So when he says he's doing 5 causes of action or whatever he's going to do for his daughters, each one of those has specific elements he's going to have to tick off, or the cause of action is just going to fold. The attorney's just going to knock it out of the water. So you just got to take your time and understand that. That's why it's good to read James's stuff and Brandon's stuff and the stuff I write. You'll start to see, the picture will start to come together for you of what taxation is, how to challenge, these runaway agencies that think they can make healthcare decisions for people. And getting them vaccinated and making them wear masks. And you'll see how to argue those issues in a court. It has nothing to do with trust law, and it has nothing to do with I'm a free man on the land or I'm a child of God. Hey, that's all great. Guess what? Not going to help you in a legal matter, okay? It's not.
It isn't. Listen, and you can see my ideological view when I write out life, liberty, and property, right? But I don't use anything that's not already written in black and white in the Declaration of Independence and in the constitutional amendments. Okay, that's it. It's all there if you want to put your ideological preference in there. But there's no reason in quoting 1 Timothy 3:15 or 1 John 3:16 in there. There's no point. That is irrelevant. Okay, just like I told you, Rule 610. Your religious views are not going to hold water in there. What we have is a set of principles of American jurisprudence and how they're supposed to operate correctly, and they are built on what's called a moral code. that moral code's invisible, but yet that's what the system's here for, and we've lost our moral compass.
Yeah, one of the deficiencies Steve told me was someone they'll send them complaints, and Steve will say, "I read 10 pages guy's complaint. I still don't know what the complaint's about." Right. You want to get out what the complaint's about right away. It should be in that first page, okay, of what you're there for, why we're here. You know, hey, these guys are falsifying their tax roll. You know, they're not even following the tax code. Hey, don't go on. People go on these philosophical journeys talking about the creator and this and that and blah blah blah. And you're 10 pages into the suit, and you got no idea why we're here, what this lawsuit's about. It should jump out at you what your suit's about.
Well, let's just do this. This action arises out of the defendant and their employees using coercion and duress to force compliance from plaintiff Sibley for refusing to take the emergency use authorized vaccination. This action arises out of egregious and malicious religious persecution by the defendant and their employees who singled out any religious objectors and persecuted the objectors through fear and examination of their beliefs. This action arises out of the defendant's retaliation against the plaintiff when the plaintiff refused to comply with the internal policy of mandatory COVID-19 vaccination. This action arises out of the defendant's violation of Louisiana Revised Statute, Chapter 46, 231.4, which states immunization compliance exceptions. C, no person shall be required to comply with the provisions of this section if that person or his parent or guardian submits a written statement from a physician stating that the immunization procedure is contradicted for medical reasons, or if the person or his parent or guardian objects to the procedure on religious grounds. This action arises out of the defendant's conspiracy to deny equal protection of the law as enumerated in the Civil Rights Act of 1964, Title VII. The causes of action brought are 1, violation of Title VII, 2, Title 42, 1985, conspiracy to deprive equal protection of the laws, 3, common law conspiracy, and 4, negligent infliction of emotional stress. I spent less than 3 minutes, and you know what this action's about.
Right.
And so that's it. I don't need to go any further than that. This is what it's about.
And Steve said, listen, I mean, my property tax suit it's like a 100-page suit, but listen, like Steve said, it's all going to come down to basically 2 or 3 things. It's really basic. The other stuff I put in there, it's just to show that, like Brandon said, how outside the state tax code they actually are. And so that's why it's so long. It's just to show, you know, here's what the actual state tax code of Pennsylvania is. Look, here's what an assessment is. Here's what a taxpayer is. And look, they don't have any evidence that I have a charter, a business license, that I'm conducting business on my property. And it's just to show that they're not even in the ballpark of following the state tax code. And that's what makes them so easy to set up is listen, yeah, these people, we debate. Steve thinks it's more out of ignorance. They do things because they just don't know it, or they're ignorant. With some attorneys, it's a combination of ignorance, and I think it's nefarious. I think some attorneys know exactly what they're doing, and they're just taking advantage of people is really what. So just have to understand that, listen, you need to learn. You're not going to get any. You can take paperwork that Brandon wrote or James wrote or I wrote and get ideas off of it, but you've got to understand the arguments of what we're addressing and how they're being addressed. Because here's how settlements work generally. When I sue the county, I'm going to sue the county in a couple of weeks for property tax stuff. What will eventually happen is they're not going to give me an answer back with no answer, and they're not going to be able to 12B6 motion it out because I got standing in the matter. You know, I could prove what I say in there. So they're going to have to give me either an answer or I'm going to get a phone call. And we're going to have a meeting. We'll set up a meeting place somewhere. We'll have a meeting. Here's what they want to know when we go in that meeting. Did I write that lawsuit, number one? They want to know if I wrote it. Or did somebody give it to me and I don't have any clue what's in that lawsuit? Or is it just something I copied off the internet and slapped my name on it? They need to know this, because when I sit down there and I go, hey, listen, pursuant to Title 61, 153.1, 155.1, a taxpayer is defined as an entity organized and incorporated under the statutes of Pennsylvania doing business in the Commonwealth. Now they know that I didn't copy this from somebody. Somebody didn't give this to me, and that I could just spew parts of it off the top of my head. I know it's in the pleading. That worries them, because they can't go into court and argue this with me, because they're not going to be able to explain how the Pennsylvania tax code defines what a taxpayer is, and obviously I meet no elements of what that tax code says. So you need to understand that's why we do these chats. Is we just don't want to basically just give you documents and say, here, go copy this. We want you to understand the actual legal concepts and the arguments so that you can make them without us. You know, we got a lot of people winning suits in our groups, and they'll take our and learn from it, but they write their own stuff, you know, and if they have questions, they'll throw their documents up in the Telegram groups, and people will give them input. Hey, I would change this. Hey, I would change that. Once you do that, just once, you start doing this, you start to get confidence. Like the girl today, Brandon will tell you. What'd she say, Brandon? I only won $500. Remember? So
that's right.
I only won $500. It doesn't matter. You won $1. Okay, you won. Okay. Bottom line is, you beat them. So that is going to be an encouragement to her to go, oh my God, this stuff actually works. When you do it right, it works. Her confidence will grow. With confidence, guess what? It becomes like a vacuum of knowledge. Now you just want to learn more. Well, if I know this much and I won, gee, let me get into this property tax stuff and let me understand how that works. And it'll just start to snowball for you, and you'll just start picking more up and more up. And as you get in the Brandon situation or my situation, and you're answering pleadings from attorneys, you'll see how attorneys answer stuff when you go, oh, let me check into that. And you'll find how to counteract that. Now you're getting more experience, because you're going to see that argument addressed for the rest of your life when you file suits. Some other dummy attorney is going to come forward, and he's going to file the same thing. You're going to go, I'm used to addressing this. I addressed it 20 times before, you know. And you'll just start to get confidence. And you don't need to memorize every law. It's not what it's about, okay? You go into whatever's before you, and you learn it. And then from that, other things will come. You'll start reading cases and go, oh, it mentions this other case. Let me go read that too. And you'll get these little golden nuggets of wisdom that are in these rulings from judges in cases where, like even in talking about service of process, Brandon, where without service of process, there is no personal jurisdiction. Doesn't matter why there's no service of process. If there's no service of process, and service of process is not somebody sticking an envelope in your, you know, the postman sticking an envelope with a 58 stamp in your mailbox. No, it's a process server coming in, actually serving you a complaint and a summons. So when you read these court cases, now you can stick that right up their rear end, because when you stick it about what personal jurisdiction is, there ain't no way that court's going to claim they could have personal jurisdiction when you never had service of process in the first place. Now they look like a rogue court.
And it goes back to everything that we do, right? You're just following procedure, right? And that's the number one thing that we don't know anything about all this, right? You have no clue. It's behind lock and door, but it's really not that complicated. Just like James sharing Rule 12G tonight, G2. It makes perfect sense, because a dispositive motion is nothing less than an answer, right? It's the workaround to not answer, right? That's what it is. So whatever defense is not raised there is waived. And that's a beautiful deal, because it's the same thing as an answer. When you answer a complaint, your affirmative defensive have to be tied to it, or they're waived. So nonetheless, all these ideas fall together. And what happens, like Alphonse is discussing, this lady won 350 or 5, whatever it was, in small claims court. Okay. What she did was go in there, test the knowledge in something small. Many of you can do this in traffic court or whatever,
I don't advise anybody to go take on Mississippi Band of Choctaw Indians or Walmart as first deal. But if you do, just know you're in for a battle. But nonetheless, it's all the same. Just like Alphonse said, and I just showed y'all this. Look, I'll show you again. What happens as you move forward in this is that you build. Now, I'm not, my templates are there, but all of them are different, right? And then you build cases like this right here, right? This is all my stuff for the PRR. If you're in the Telegram group, you can find everything with PRR. That's Pearl River Resorts, right? And everything that I have here is where I just go pull my template from, and I instantly have one of the hardest parts to do, which is my top portion, right? And my verification, and everything's already in. I'll just copy and paste it over. My verification's there, and so is my jurat, right? Which is my inside my verification, and then my certificate of service. It's all there. So every time I start, everything's already there in my Word document that I need. And you just clean it up as you move forward. As a matter of fact, some of the stuff that the lawyers have sent me, I've gone, hey, that looks pretty cool. Let me try that.
Yeah, I pick things off of lawyers. I've said, oh, okay. You know, sometimes you'll pick a little trick off of somebody.
Yeah,
oh, I didn't think of that.
Yeah, I didn't think of it. And use it. Look, to not use the brain of somebody else is to admit that you have no brains yourself.
How about this one, Brandon? Here's how to answer your motion. They'll instinctively, like they'll say denied is a legal conclusion and requires no response. The attorney does, right? So why don't you answer his thing the same way? Yeah. Total 53 applies. Denied. It's a legal conclusion and requires no answer. Because isn't he doing the same thing? Didn't he just make a legal conclusion?
Yes, he did.
He make legal conclusions. So I took a lot of that stuff and I've turned the tables on them and just handed it back to them. Oh, here you go. Here's your stuff right back to you. You know.
All right, my friend. We've gone 2 hours. We'll now that since the Choctaw Indians and the other one is in a position where the judges have to rule, and the city of Central, and I'm about to fire off the next two. So I've got the hospital for my daughter, and then I have wildlife and fisheries that's going out before the end of the year. That'll be the next two. We'll probably do a couple more sessions before the heat of the moment starts again on the next volley. So I'd like to see you again soon, brother, and you take it easy.
Yeah, and listen, now that I've learned that the locals are actually neutered, like I think your woman found is a peppermint patty, yes. Where basically they can't take the home. The locals with their tax stuff, even though they're moving under this tax claim law, they can't take the home. Okay, not the county. I'm talking about your borough, your township. So to me, they're like mosquitoes. Okay, it's just like trying to get away. Get away, because when the property tax suit goes on, it cleans them all up. So that's something to learn basically too, is that's how Pennsylvania works. I got the judge wrote it right in there. I think the judge did it in her case too. He said, no, that they can't take the property. Okay. They can't take the property. Oh, okay. So why am I going to waste any more time with these local fleas? I'm just going to say, hey, you know what, you guys go do what you want. You file anything you want against my property. I'll deal with you when the property tax suit gets filed. Then you guys will come in and I'll take all the stuff you filed as liens. You people could come in and explain how you filed liens against property you have no ownership, interest, or taxable interest in. I can't wait for your answers. So that's where I'm heading for the property tax suit. Just got to get my exhibits over. There's too many of them. I got too many exhibits, okay? Trying to narrow them down.
And it's tough when you have 3 years, right, of stuff, dude. That's just, and that's what's going to end up happening if they keep moving this damn Mississippi Band of Choctaw Indian stuff down the road. And of course, I grasp that this has huge implications on all the tribes across the nation who run casinos, right? But I didn't go force those people to enter into commerce. That wasn't my decision.
You're hoping you and say, hey, listen, this is getting ridiculous. Their lawyer fees have to be high as hell paying this guy, He sent you 500-page documents. How long did it take him to put that answer back together, that motion, whatever that was? So your phone book,
Gary was in politics at one time. He's and from his view, and the level that this lawyer is, he's saying that at least 300,000 so far. I put it on the low end. I'm thinking 150 at the very least, but with 40 documents and the amount of time that he's charging for people watching my YouTube videos, remember, that's billable hours.
Right.
Each one of my
God forbid you go to trial. Now what is it going to cost them if this goes to trial?
Yeah.
Now you're talking big money for that attorney.
Yeah. So again, it's one of these things where for so long, because they get to hide under the advocacy of their client. Well, that's great, but you're supposed to do the research. You're supposed to validate, and once you find out that your client is guilty, do you continue? Are you supposed to logically and morally continue to defend them? Well,
no, they're supposed to fix it. They're supposed to fix it.
Now no. What he's supposed to do is come meet me at the table and say, "Oh, by the way, we're going to settle." That's what he's supposed to do.
Yeah. That may still happen. That may still happen.
Yes, they do. And as a matter of fact, it's in one of my motions that the Mississippi Band of Choctaw Indians accepted $57 million in COVID relief.
So they got a lot of money to distribute to you. They got a lot.
They do. They do. And the fact is, inside that relief is, at any point does the tribe commit any racial discrimination, right? And that's in my pleading. That, hey, we're Indians. We can do what we want. And he tells me, we're sovereign. You're not. That's a discriminatory animus, folks. That's what that is. That is racial determination. That's what it is. Me, the white man, I don't have the same sovereignty as they do, right? And, of course, that's been taught to them. This is the victim mentality being taught to people over generations, and this is what happens. They become the oppressors instead of the oppressed.
Ain't that funny?
Yeah.
The people that were, once they get a little bit of power back, they become the oppressors.
It's the same cycle. It repeats itself. We see it now, right? And so it's unfortunate. It's on the record, the actual payout of $57 million. It's in the it's an instantly admissible evidence because it's from a newspaper article. So it's already on the record. And as a matter of fact, one of the things that you can do is if they lose this case, I can actually write the DOJ and have that money refunded. So, there's a lot of money up at stake here for the Mississippi Band of Choctaw Indians.
What if you could quo Toronto their charter, right? They're operating under what? Some kind of peace pact, whatever they have.
No. So in I can't remember the year now, but the United States no longer operates under treaties with any of the new Indians. So when they created the shell corporation called the Choctaw Resort Development, that corporation operates strictly under statute. It does not have a treaty.
So they're really just they're McDonald's or General Electric or
they're
whatever.
Just a local government. That's all they are. They're a local government with administrative courts, and the tribal chief is the dictator. Nice. That's really all they are. They're really nothing different than a municipality with a territory and inhabitants, members of the association.
Yeah.
I would actually put them closer akin to a private member association, like a private club. Yeah. But nonetheless, you have to be a member to be a part of it. So they have a local government. All right, brother, you have a blessed time. We love each and every one of you out there.
Have a good one.
I hope y'all enjoyed it. All right, let's end this thing.